The Ateneo Alumni Association has evolved from its image of a boys' club in the early years to the image of an active alumni association of men and women for others.
I think it's very important to remember that the Ally performs a very important education value. The education of our graduates ends not with graduation, but with their continuing practice in introduction into the legal world.
This is a big task, but I believe everything is possible as long as you believe in our dear Lord. And as Atenean lawyers, we do believe. And with your help, we will be able to do it. Let us continue to be men and women for others. Join the Ally.
Join us! Join us!
Join us.
The Ateneo Alumni Association has evolved from its image of a boys' club in the early years to the image of an active alumni association of men and women for others.
I think it's very important to remember that the Ally performs a very important education value. The education of our graduates ends not with graduation, but with their continuing practice in introduction into the legal world.
This is a big task, but I believe everything is possible as long as you believe in our dear Lord. And as Atenean lawyers, we do believe. And with your help, we will be able to do it. Let us continue to be men and women for others. Join the Ally.
Join us! Join us!
Join us.
Good afternoon to everyone. Welcome to the Ateneo Law Alumni Association online forum on the Anti-Terrorism Bill. I know that we have a number of televiewers or listeners and viewers at this time, and they would want to know the reasons for this particular forum. Why was this formulated in the first place? First, this is to provide a platform for opposing sides to discuss their views on the anti-terrorism bill. We would want the parties or the public to get to hear what the proponents would say and the oppositors would have to say. Second, I think in line with Ateneo Law Alumni Association's objective, which is to educate the public, our real intention is to be able to show what the law has to say. And in this afternoon, we will try to discuss it in a very objective manner. And at this point in time, and this is consistent with the discussion with the Board of Trustees of the Ateneo Law Alumni Association, led by its president, Nena Rosales, and our chairman, Attorney Teddy Cruz, we would like to tell the public that the association is ready to assist in educating government agencies or helping them understand certain provisions of the law or laws for that matter, so that there will be no problems in implementing the law. Okay? So with that, I think it is to introduce the participants in this forum. Let me start with, of course, I will give a rundown first, the presenter. The presenter is known to a lot of us because he's the principal author of the Anti-Terrorism Bill. And he is Congressman Jericho Coco Nograles. He's a graduate of the Ateneo de Manila University. The reactors are composed of the following. And before I proceed, kindly take note that the presenter will be given 20 minutes to say his speech, to highlight what he thinks are the reasons why the law will have to be passed. There are 3 reactors, all given 8 minutes to present their side. First is in the person of IBP National President Domingo Egon Cayosa. The second is General Attorney Florentino Manalastas, presently the officer in charge of the Anti-Terrorism Council. And the third, of course, is a member of the Ateneo faculty and the executive director of the Ateneo Human Rights Center, Attorney RP Santiago. Once they have presented their sides, then the floor will be open for question and answer. But before I proceed to give you the presenter, let me give you a rundown of the rules very quickly. Aside from those that I have mentioned, every participant will be given a chance to answer a question for a period of 2 minutes. And they could only speak once the moderator. Okay? If anyone would like to say a comment from among the reactors or the participants, they will be given a chance, but only when a question has already been posed on them. I think with that, the online forum is now ready to roll. Okay, with my introduction, and I would like to thank everyone for your participation. I hope that this will be a fruitful afternoon for every one of us. Now let's start with Congressman Jericho Coco Nograles.
Good afternoon, everyone. My profound thanks to the Ateneo Law Alumni Association for inviting me to in today's discussion and today's forum. I hope that in today's forum we'll be able to have a healthy discussion on the merits and the issues that abound the anti-terrorism bill. I'd like to give my sincerest thanks, of course, to the chairperson of the Ateneo Law Alumni Association. That would be Attorney Teddy Cruz, and the president as well, Attorney Filomena Legaspi Rosales, and all the the members of the board of trustees. I also want to give my respects to IBP National President, Attorney Domingo Cayosa, the OIC-Executive Director of the ATC-PMC, Attorney General June Manalastas, and of course, our Executive Director of the Ateneo Human Rights Center, Attorney RP Santiago. And thank you, Attorney Salvador, for moderating today. So let's begin, ladies and gentlemen. I have to admit that I had much difficulty in preparing for today's discussion and today's topic. First of all, I'm given 20 minutes. And for me, 20 minutes is not enough to discuss the full context of the anti-terrorism bill. And that, I believe, is the number one problem of the anti-terrorism bill right now. A lot of people don't understand the context, mainly because a lot of people have not taken enough time. When the issue on the anti-terrorism bill escalated, and a lot of people messaged me either against or in support of, I asked each and every individual if they have read the anti-terrorism bill. And I kid you not when they say 100% of the time, they have not read the bill. So the initial reactions really were sharing of a lot of, might I say, propaganda or very quick assumptions, conclusions to the bill, which I think would be unfair. And so in preparation of today's opportunity to explain the bill, I had to reflect on the 7 years of this bill being in the legislative mill. 7 years. That means that it was first, amendments to the anti-terrorism laws were first introduced as early as the 15th Congress. I think it was through House resolution filed by Congressman, same party list as the good Senator Trillanes. But anyway, I forget. But 7 years in the legislative mill, spanning 3 Congresses, the 16th Congress, the 17th Congress, and now the 18th Congress. And the way that you look at the anti-terrorism bill, and at least the way that I look at it, is that it is an amalgamation of existing constitutional provisions, existing laws, existing rules and regulations, existing international covenants. And there is barely anything new in the anti-terrorism bill if you understand or you have read and you have researched all the related laws and constitutions and conventions when it comes to the law. In fact, I dare say that the anti-terrorism bill has even 13 years of experience in all the provisions that are similar to the Human Security Act of 2007 or RA 9372. It has 19 years experience in all the provisions of the UN Security Council Resolution number 1373, which was passed in 2001. That's 19 years. And a lot of the UNSC Resolution 1373, a lot of it is not even present in our existing laws. It is the anti-terrorism bill that actually puts it and codifies it in our laws, even if UN Security Council 1373 has already been, it's a covenant and we are signatory to that covenant. It's been 8 years already since Republic Act 10168 or the Anti-Terrorism Financing Act of 2012. It's been 15 years already with the UN Security Council number 1624 and 3 years with UN Security Council Resolution number 2396, covenants of which the Philippines is a party to. And in the process, I actually prepared 4 different PowerPoint presentations, which are particularly difficult because I haven't done a PowerPoint presentation since my MBA days. And that's about 10 years ago. And so in those 4 different PowerPoint presentations, I tried to do justice for today's presentation by presenting the history of terrorism in the world and in our country, as well as the current recruitment trends of terrorist networks to give everyone in the Ateneo alumni community and all those who are present today an understanding of what the real world is. Just a tip, a pro tip, try to search Maria Resa's Rappler article on the recruitment of terrorist groups. She published it in 2015, beautiful article. Try to get her book as well. She's an expert when it comes to terrorism and how people are recruited and the evils of terrorism. And of course, how it preys on the weak and the hungry. Another presentation I made, which binasura ko rin, is the immediacy of the need of anti-terrorism bill, because the Financial Action Task Force is set to gray list the Philippines on October of this year if we do not update our anti-terrorism laws in conformity with international law. And if we don't do that, then we will be placed on the gray list, and it would seriously and adversely affect our economy, which is bruising badly right now with COVID. And this would entail hurting about 13 million OFWs and getting lesser and lesser because more OFWs are losing their jobs and coming back home. It will hurt the BPO industry. It would hurt our micro and small medium industries for their sales, offshore sales, the income of dollars, the outflow of dollars. It's going to seriously affect. And not to mention, when other investors would look at the Philippines and see that we are on the gray list, they will pull out. Likewise, the hot money in our stock markets, the moment that we get gray listed, they're gonna pull out the money and their investments in the Philippines, and investor confidence is going to fall. Again, that kind of talk is not enough in 20 minutes. Likewise, the history of and the situation of terrorism in the Philippines is not enough in 20 minutes. So, binasura ko na naman yan. I was thinking of going straight at it, line by line in every single question on Section 29, on Section 4, on Section 5, 6, 7, Section 16. One by one, I'll just present it on PowerPoint so that, I'll flash it on PowerPoint in its entirety, and then we'll discuss it line by line, why, and then I'll talk about the constitutional basis, and then basis in international law, the basis in our existing laws. And then I realized na 20 minutes is not enough. The last PowerPoint presentation that I actually prepared, and I spent the whole day yesterday about it, I like it actually, because what I did is I listed down the Bill of Rights, because a lot of people say that the anti-terror bill goes directly against Article 3 of our Constitution. So one by one, the Bill of Rights, and I posed the question: is this right challenged by, or utilized, or maximized, or abused, or by the anti-terrorism bill? And I did it. I had 52 slides. And then I realized 52 slides in 20 minutes, everything that will come out of my mouth would be gibberish already. So binasura ko yung 4 that I've been working on since the invitation sa Ateneo. And basically, aside from the time limit, I found that it would be unfair to the affected communities meaning those who are continually living under the threat of terrorism, have actually changed the norms of their lives. And I could say this because I've had personal experience on that, and professional experience on that, on how terrorism could change the landscape of a town, a province, a region. And it has. And we can't ever forget terrorist attacks. If you have, it's easy to Google terrorist attacks in the Philippines. The deadliest being Super Ferry 14, that killed 116 people, done by the Abu Sayyaf. And not to mention the suicide bombing last year at the Holo Cathedral, the first ever suicide bombing in the Philippines, done by foreign terrorist fighters, and subsequently by the first suicide bomber, Filipino, at Indanan, also in Sulu, Very, very sad day for our country and our democracy. Also, it would be an injustice towards law enforcers, an injustice against the critics of the bill, because ayoko naman na tingi-tingi at saka bitin yung presentation. So I'm stuck with this problem, no? How do I present in 20 minutes? And I go back to how, as the principal sponsor, I can't claim to be the author because we adopted the Senate version, but I can say the principal sponsor, and how I sponsored it on the floor at plenary in Congress. And my sponsorship speech, I will read again for the Ateneo community. I read directly from the bill itself, Section 2, the Declaration of Policy, which as a legislator, I believe is the spirit of the law. More than the definition. A lot of people say Section 4 definition, yan ang spirit of the law. No. The spirit of the law and every law, I believe as a legislator, is the Declaration of State Policy. And thus I read. It is declared a policy of the state to protect life, liberty, and property from terrorism, to condemn terrorism as inimical and dangerous to the national security of the country and to the welfare of the people, and to make any terrorism a crime against the Filipino people, against humanity, and against the law of nations. In the implementation of the policy stated above, the state shall uphold the basic rights and fundamental liberties of the people as enshrined in the Constitution. The state recognizes the fight against terrorism requires a comprehensive approach comprising political, economic, diplomatic, military, and legal means, duly taking into account the root causes of terrorism without acknowledging these as justifications for terrorist and/or criminal activities. Such measures shall include conflict management and post-conflict peace building, addressing the roots of conflict by building state capacity and promoting equitable economic development. I've always maintained, and I've said this in the IBP forum last week, that the root of all crime, terrorism included, is inequity. This anti-terrorism bill will not solve terrorism alone, but it will empower us, our government, our state, to fight terrorist activities and prevent terrorist activities. But terrorism is different from terrorist activities. To fight terrorism, you must go into the inequity of it all. Something that Ateneo taught all of us. Now, it is curious to note that the criticism and the question on constitutionality of the provisions of the anti-terrorism bill exploded. It became, in current terms, viral when the president certified the bill as urgent. Now, here is my question. Is it really unconstitutional? And everyone else, a lot of the critics would say, it's unconstitutional, and then they'll say Section 29, so and so and so. Valid concerns, but in every single argument that I heard, it needs context. The demand of the anti-terrorism bill is that when you read it, a terrorist act must, by its nature and context, be a terrorist act. Otherwise, it's a simple crime under the revised penal code. But when it is used by its nature and context for the promotion of terrorism, then it becomes a terrorist act. I remember somebody from the showbiz industry asked for a Zoom meeting with me and told me his side. And he said na, yeah, insurgency, etc., etc., etc. I had to stop him. I said, hey, insurgency is different from terrorism. There's a big difference. And when he realized that, he saw that, oh, okay, I need to further read about it. Likewise, a lot of people who I encourage to read suddenly formed their own educated opinion. And for me, I'm all for that. You're entitled to your own opinion. That's cool. That's cool with me. But again, as a politician, I'd have to say that this explosion of criticism is, and a lot of them, a lot of the propaganda is politically motivated. And it is important for lawyers, those practicing in the legal profession, to stick to the facts. I mean, simple lang yan di ba? You go back lang to the code of ethics. You have to stick to the facts. You go back to your oath as lawyers. The same way that I go back to my oath as a congressman to uphold and defend the Constitution, which is precisely why I have to argue that Congress, the Senate, and the House of Representatives is presumed to pass constitutional laws. Because you have to believe that we swear to uphold and defend the Constitution. And of course, the presumption of regularity. Because in passing a law, it is not unilateral. It's collegial. It goes through a process, public hearings, public debates, and it did. For 7 years, at least for this bill, for 7 years, it went through the process. 7 years and 3 Congresses. And if you want to talk about unconstitutionality, I think we will all agree that the Supreme Court is the final and only arbiter of what is and what isn't constitutional. Whether the law is unconstitutional or a part of the law, a provision of that law is unconstitutional. Supreme Court na magsasabi, hindi tayo. But tayo, as congressmen, presume that it is constitutional. Now, I have to comment that a lot of those who oppose the anti-terrorism bill have publicly pronounced that the moment that the president will sign this into law, they will march on to the Supreme Court and file a case about these provisions that are unconstitutional. I mentioned earlier that the anti-terrorism bill, in my opinion, and in the opinion of a lot of other colleagues of mine, both in the Senate and the House, and yes, please, the Senate are my colleagues because we have the same salary grade. That's a joke. A lot of pronounced that they would go to the Supreme Court the moment that the president will sign it into law. My question is, why wait? Why wait for the president to sign it into law? Go ahead and go to the Supreme Court and question it. I know what you're thinking. You're probably thinking, hindi pa nga napirmahan, wala pang justiciable issue. Oh, time out. Let's break down the major issues of the anti-terrorism bill as we understand and has been talked about in the IBP, on TV stations, on radio stations, on the internet. Let's break it down to 5. They say that there's a broad definition of terrorism. That broad definition of terrorism has been around for 8 years. If you don't believe me, I'd like to refer you to Republic Act 10168 under Section 3 of that Republic Act, which also includes preparatory acts for terrorism. It's been around for 8 years. Nobody questioned it in the Supreme Court. You want to question it? Go ahead. Don't wait for the ATB to be signed. Another issue, designation. Designation has also been around for 8 years. Also in Republic Act 10168, Section 3 as well. In fact, there is a justiciable issue na, if you want. May designation na under 2017 order of the President designating the NPA as terrorists. Proscription has been around since Republic Act 9372. 17 years na yan. And it's been questioned in the Supreme Court twice. In fact, one of the petitioners is Harry Roque. And the Supreme Court upheld the constitutionality of 9372. Surveillance, also 9372, upheld by the Supreme Court. Arrest and detention, yan, Section 29, upheld by the Supreme Court. Section 18 yan of RA 9372. You can actually question it already. you don't need to wait for the Supreme Court, for the ATB. I know I need to close, Attorney Salvador.
Thank you, Congressman.
I see you na.
Yes.
I know I need to close, but let me say this na lang. Sadly, there's a lot of uninformed opinion, but that's granted. It happens. Fake news happens a lot. But what really offends me as a public servant, as with all lawyers being agents of the court, bound by your oath and your ethics, that there are clear misrepresentations. And these clear misrepresentations, especially by lawyers, should be avoided. I would like to state one very important misrepresentation that just happened last Monday. I don't know if Attorney Cayosa is in. Is he in already?
He will
I
be
don't know if he's
reacting.
in.
Yes, he will be
Okay.
in. He'll be
Yeah.
reacting.
Attorney Cayosa, I know you're listening, but in your letter to the Deputy Executive Secretary for Legal Affairs, and that's the Office of the President of the Republic of the Philippines, you mentioned there that you put words in my mouth, that I admitted that there is unconstitutionality in the bill.
Okay.
I would like you to not do that.
We
That's
will,
not true.
Congressman, we will allow President Cayosa to give a comment on that point later on. Okay? Your time is up. Now we will proceed to the first round.
Okay. Thank you.
Salamat, Congressman
I hope I
Coco.
gave
Stay there,
good
and we'll
context
ask you some questions. Thank you. The next speaker will be IBP National President Domingo Egon Cayosa. He will be giving his reactions on the anti-terrorism bill.
Thank you very much, Tranquil, and thank you to the Ateneo Law Alumni Association, the presenter, Congressman Nograles, and all the other reactors. The Integrated Bar of the Philippines is an ally in the war against terrorism, because terrorism is the antithesis of the fundamental premise and foundation of the legal profession, and that is the rule of law. And I agree with most of the premises laid down by the good Congressman Coco, because we all know that terrorism has to be addressed. So IBP, by the very nature of our profession and the mandate of our organization, every now and then is invited to comment on crucial legislation. In this particular case, the Office of the President, through the Deputy Executive Secretary for Legislative Affairs, requested IBP to submit its comments and recommendations on this bill, which are not really new, because these comments have been expounded in many public fora. So let it be made clear to everyone that IBP does not play politics, and we should not play politics. As a professional organization, we must focus on the law and focus on the constitutionality. And that's exactly what we did in our submissions to the Office of the Deputy Executive Secretary for Legislative Affairs. The anti-terrorism bill is very long, but we only focus on those specific provisions which, to the mind of many lawyers, academicians, experts, even legislators, are constitutionally infirm. Number one, we start with Section 29. And I agree with the legislators that we should look at the law in its context. And that's why we look at the law in its context. But even before we do that, we should just read what the law says, because the law, to be a fitting legacy, must be clear to everyone, to the ordinary citizen, and the executive will implement, and the judiciary will interpret the law based on what it says. So Section 29 is pretty clear that the arrest and detention of suspected terrorists by law enforcement agents or military personnel by written authority of the ATC can be extended to 14, maximum of 24 days. To the mind of many lawyers, including IBP, and the Constitution is also very clear. The power to order the arrest of individuals is exclusively vested by the Constitution to the courts of the land. As a matter of fact, in the letter of Senator Lacson to IBP, he admits and he yields that only courts can issue arrest warrants. However, the explanation, and he said that he did not intend the ATC to have the power to authorize arrests. Unfortunately, his clarification does not correct the law as submitted for signature and approval of the President, because the law is very clear. Especially so if it is taken, Section 29 is taken together with Section 25, which gives the ATC the power to designate ex parte without any hearing and on mere probable cause anyone, a person or organization, to be a terrorist, suspected terrorist, and that results to the possible freezing of his accounts by the Anti-Money Laundering Council or upon the by itself or upon the request of the ATC. So malinaw yung kanilang powers. There is a proposed excuse now saying that no, Section 29 actually refers to allowable warrantless arrest under Rule 113. But if you look at the law itself, it doesn't say so. As a matter of fact, if that's the case, there's no need for Section 29 because Rule 113 can be used by any law enforcement agency even without the ATC's written authorization. Secondly, Rule 113 that allows warrantless arrests envisions a situation where the law enforcer himself is underground, sees the crime being committed or about to be committed or just committed, and he has to do hot pursuit, would be so senseless because now Section 29 says you have to get a written authority from the ATC. So to our mind, these explanations, and of course, in the webinar, the good congressman suggested that perhaps whatever gaps there are in the law can be cured in the IRR. It's a noble idea, except that the clarifications or the good intentions or the proposal to improve it through the IRR do not change the letter of the law. So that's our point with respect to Section 20. It may be well-meaning. It is welcome clarification from the two distinguished legislators. It doesn't change the law. And that's why we still raise the issue of unconstitutionality. Secondly, the power of the ATC to designate ex parte and to have that consequence of freezing of your asset by AMLA is tantamount to taking of property without due process. Please take note that yes, Tranquil?
Attorney Egon, your time is up. We will have for you as we move along with our question and answer. Please hang on to your other ideas. We will proceed with our next reactor. Thank you very much for those ideas. We will proceed with General Florentino Manalastas, who will equally have 8 minutes, the OIC-Executive Director of the Anti-Terrorism Council. Thank you.
Good afternoon, everyone. So, the presenter spoke in general terms. He did not cite any specific provision of the Human Security Act, and therefore, I prepared actually some points about the one tackled by Attorney Cayosa, that of Section 29. but I reserve that during the discussion later. I just would like to express my opinion of support to the bill being very much timely, and we really need that. Some critics would say that the Human Security Act is sufficient, and they say that if the issue is just the 500,000 pesos fine for excessive detention is the issue, then they propose that that just be lowered through an amendment. They bank on the popular proverb that if it ain't broke, then don't fix it. We at the Anti-Terrorism Council say that the amendment is long overdue. The Human Security Act is weak, ineffective, and outdated. We feel that for a long time, we could attest to it, being the agency attending to anti-terrorism matters. The record of just one conviction under this law since it took effect in 2007 is a glaring evidence that it is weak. It is outdated because so many developments transpired since then, which the Human Security Act could not address. The ISIS, suicide bombing, foreign terrorist fighters, the sophisticated way of transferring funds and other schemes and concepts are never heard of during that time. Many terrorist-related offenses were also not covered by the Human Security Act. If you are a frontliner in the fight against the terrorists, you would not like to be out there and be butchered by ruthless terrorists who are enjoying the protection of a terrorism law, which serve as a burden to the law enforcers instead of being a potent weapon. A frontliner must have the upper hand. He must be properly equipped, including that of a robust law, which paralyzes the enemy. So this ATB is an upgrade, if this is to be considered as a machine. It has included additional terrorism-related offenses, which are not punishable in the Human Security Act. It even increased the membership of the Anti-Terrorism Council from 7 to 9, with the addition of the Secretary of Information and Communication Technology and the Executive Director of the AMLAC. Some agencies are also added to the list of support agencies because of their relevance and added value to the anti-terrorism capability of the country. And while the onerous 500,000 pesos fine has been removed, something has taken its place, although not pecuniary in nature. The ATB punishes erring law enforcers who will exceed their power beyond that provided by law. The crafters of the ATB anticipated and therefore provided many safeguards against abuse of authority by the law enforcers. Section 33 absolutely prohibited the use of torture or punishment at any time during the investigation or interrogation of the detained suspected terrorists and provided punishment for perpetrators. Any evidence obtained in violation of such prohibition will be of no value and is entirely inadmissible in any forum. This enrolled bill is a product of the efforts and many reasonable and brilliant minds who crafted the initial draft, which had undergone many deliberations and scrutiny by legal luminaries, by human rights advocates, and other experts. During deliberation in the Senate, it was revised a number of times to accommodate the inputs from opposition senators like Senator Franklin Drilon, Risa Hontiveros, and others, including even some co-authors of the bill, so that the infirmity could have been identified and addressed. The senators are known for their integrity and principle, having been in almost all of Senate deliberations of the bill. I personally observed how they grilled the author, Senator Lacson, in many occasions. Their inputs have been incorporated in the bill. My point is this: there could be no end to the discussion on this bill, especially if we invite lawyers, as there will be as many opinions as there are lawyers. We at the Anti-Terrorism Council Program Management Center agree with the presenter about the need for the approval of this bill to protect the freedom-loving Filipinos, to protect you, to protect us. And if there is a question as to its constitutionality, the presenter has said it, let the Supreme Court decide. For the meantime, once it becomes a law, it is presumed constitutional. Sad to say, some would consider this like an unwanted unborn child, a fetus, which they would abort before it is born. Let us give it a chance to live, to work, and to prove its worth. The life that could be saved in the future terrorist attack because of the deterrent effect of an effective anti-terrorism law could be yours. That's my reaction. Thank you.
Uh, thank you very much, General Attorney Manalastas. You had only 6 minutes. You been given the chance to consume 2 minutes more. But thank you for your presentation. Let us now proceed to the next reactor in the person of Attorney R.P. Santiago, a professor of law at the Ateneo School of Law and executive director of the Ateneo Human Rights Center. Please proceed, Attorney R.P.
Thank you very much, Mr. Tranquil. Thank you very much to the Ateneo Alumni Association for this opportunity to have this brilliant discussion this afternoon. My greetings to my fellow co-panelists, Attorney Egon, Cayosa, General June Manalastas, and our principal discussant, Kong Coco Nograles. I myself have been involved in the discussions before in the technical working group meetings of the Human Security Act. And it is true that even before, the broad definition of terrorism had always been a point of contention and discussion. And one thing that we learned there is that ultimately it is a game of numbers. If you have the numbers, then it would fly. So we have the Human Security Act, the Republic Act 9372, and at the time that it was being deliberated as a bill, it was overemphasized that it is much needed. Okay? Many years after that, more than a decade, we only have one conviction, as mentioned earlier, and it was said that it is really inadequate at the moment. Okay? I will not discuss the adequacy or inadequacy of the said law at the moment. I just want to point out that because of the broad definition there, the deterring factor is the high fine that was put there, at least 500,000 peso per day of misuse, for example. Ateneo Human Rights Center, together with many human rights groups, also agree that addressing terrorism is a serious concern. We are one with our legislators, our executive department, in trying to address this concern of terrorism. But the law itself is merely a tool. The law is not the solution, the end-all and be-all. And again, the reason for the deterring factor in the Human Security Act is a recognition that some of the actors that actually might implement the Human Security Act might not be properly equipped in really implementing it. In short, it can be subject to abuse. Because of my discussion on my topic is on human rights, I want to focus on a particular provision on the Bill of Rights of our Constitution, particularly the right of the people to be secure in their persons, of whatever nature and for any purpose. And this is held to be inviolable. Okay? And because of this, a warrant of arrest can only be issued by a judge, only after probable cause, based on a personal determination of the judge. The reason for this is to limit discretion on those implementing the law. That's why you have the judiciary. But it was already mentioned earlier that under our rules of court, there is an exception to the rule that there should be a warrant of arrest. It is when a person is arrested in flagrante delicto or caught in the act. Okay? The least factor is that there should be personal knowledge of the arresting officer. Personal knowledge. Okay. Now, I want to focus on Section 29 of the Anti-Terrorism Bill. It is titled as detention with judicial warrant of arrest. Detention. It does not talk about arrest. It talks about detention. Okay. It says that any law enforcement agent or military personnel which has been duly authorized in writing by the Anti-Terrorism Council can take into custody a person suspected of committing any of the acts. Okay, and there's a gamut of acts that can be committed under the Anti-Terrorism Bill. When we talk about taking custody, it doesn't necessarily mean that it is that person, it is that law enforcement agent or military person that actually arrested the person. That person could have been arrested by someone else, but this talks about detention. And you can detain a person, which is something new. And this is what I think Kong Coco was looking for. What is something new? It's not merely an amalgamation of existing laws, to borrow his words. But something new here is that you can arrest a person who is suspected. I would emphasize on the word suspected. The exception on warrantless arrests talk about a person who is actually committing a crime. Now, based on this law or this bill, when it becomes a law, you can arrest a person and detain a person who is merely suspected. In short, the detention allows for further investigation. It allows for a fishing expedition. It allows detention for a period of 14 days up to 24 days. And there is even no requirement that you will file charges against the person. It just says, oh, kung 24 days na and you feel that no charges should be filed, you're only able to detain but not file charges. Okay? So there's a number of acts mentioned there. What is the deterrent or the safeguard? The safeguard is merely to notify the judge in writing of such detention. Notify the judge. The judge can't do anything. There's no case before the judge. Okay? And furnish the Anti-Terrorism Council and the Commission on Human Rights. They themselves have nothing to do. Okay? They can only monitor. Okay? And it says that, again, the safeguard, allegedly based on the law, is a penalty of 10 years for what? Not for the wrongful arrest, if ever, but only for the failure to notify a judge. So that's it. That's the only safeguard. Okay. I want to, since my time is almost up, I want to just show what is our environment right now. Just a couple of incidents this past 2 months. I'll read some headlines. Teacher arrested over tweet to be charged in court for inciting to sedition. NBI files inciting to sedition complaint versus Bicoy video sharer. Terror bill protests. Cebu cops arrest inside UP campus. Inciting to sedition raps filed versus a clanman who offered 100 million bounty on Duterte's head. 25,000 quarantine violators arrested. And then PNP chief, quarantine violators face immediate arrest without warning. And this is where I agree with Kong Coco that context is very much important. I want to contextualize that we have to minimize discretion that would be given to law enforcers on arresting people based on what they think or who they think are suspected of terrorist activities. Whether that person is actually a terrorist or not, it would be determined by a judge. But what would happen in the meantime? That person can be subjected to an administrative detention without any court intervention for up to 24 days. And that is the discretion that our Constitution is really preventing. Okay?
Thank you very much. You want to finish it?
Okay, my last point is inequity, okay, which was mentioned by Kong Coco. Inequity, there is inequity in access to justice, especially by those who are usually arrested without warrants. And I can further elaborate later. Thank you very much for the time.
Thank you very much for that, Attorney RP, for that more detailed presentation. Now, we are now at the question and answer portion. And should you have questions for those of us who are watching, for those of you who are watching, please feel free to send your messages and I will be able to read it and to see it. But I think I will now have to address and first remind our speakers entitled to 2 minutes to respond to questions. Okay. Let me address the first question to, of course, our presenter, the main man. Okay. I think you've noticed that Attorney Cayosa, president of the IDP, and Attorney RP mentioned Section 29. And I think you know that most of those who really oppose this have been harping on Section 29. You're fully aware of that. Now, let me break this down into two questions for the benefit of our listeners, okay, and those who are watching us right now. I think the first question that we would like you to answer would be, why is it 14 days of detention when, if we look at the human security law, the law that it wanted, okay, to supersede, it was only 3 days. Okay, just to give you the background. Under the human security law, 3 days. Under the proposed bill, 14 days. And I would like to state also that under Article 125 of the revised penal code, it is the duty of the arresting officer to deliver to the judicial authorities within a period of 36 hours for capital or afflictive offenses, that which would carry afflictive penalties. Now, I think that is one very important question. And let me finish the second question, which was raised by Attorney RP. The word suspect, it gives so much discretion to the Anti-Terrorism Council. Sospecha ko ito yan eh. How well, upon which they could say that this person could be truly arrested. While there is Rule 113, Section 5 that allows warrantless arrest, to their mind, it doesn't fall under Article 113, Rule 113, Section 5. Please, Congressman Coco. So we have two questions for you related to Section.
Two questions in 2 minutes. All right.
Yes.
First of all, I'll answer the second question first, no, which is the suspect. No. First of all, I mentioned that this is an amalgamation of existing laws. And I mentioned earlier that as far as arrest is concerned, that was already existing and currently existing under the Human Security Act of 2007. In fact, if I read directly, it says, any law enforcement personnel who, having been duly authorized in writing by the Anti-Terrorism Council, has taken custody of a person charged with or suspected of the crime of terrorism or the crime of conspiracy to commit terrorism shall, without incurring, so on and so forth. It's existing law. You can take it to the Supreme Court now.
So what you're trying to tell them is that this is not something that is new.
Not new.
The word suspect.
The word suspect and also the authorization of the Anti-Terrorism Council to a law enforcement agent. It exists in Section 18 of the Human Security Act of 2007, existing for 13 years, questioned in the Supreme Court twice, and failed. Yes,
Okay.
RP. Parang RP wants to say something.
Congressman Coco, I will allow him to comment on that point.
It's
Okay, RP.
It's healthy naman. Healthy discussion.
Oo. Sige, thank you for bringing it up, Kong Coco. There are two things that are different right now. Number one is the deterrent factor. Okay, as I mentioned earlier, the 500,000, at least 500,000 pesos a day for wrongful detention has been removed. Okay, this actually deterred law enforcement officers and agencies from arresting suspected people. Kasi there is that deterrent factor. And as I pointed out earlier, it's not existing anymore in the current anti-terrorism bill. What is the security factor there, or security measure, as mentioned in Section 29, is merely to inform the judge that an arrest actually happened or a detention actually happened. The second point, and to address, Kong Coco, your concern about the Supreme Court case, and you mentioned sila Harry Roque pang nagdala nito. It was dismissed on a technicality. The technicality there is that there was no justiciable issue at that moment because no one has yet been arrested. In short, pasensya na sa technical to our viewers who are non-lawyers, that's what you call as a facial challenge. And in a facial challenge, mabilis na lang. In a facial challenge, what is different here is that you now are criminalizing inciting to terrorism.
So
which
that would
talks
be a different
about
topic.
speech. Oo. Pero yun
Attorney
yung
Harvey, that's
different
a different
ngayon na pwedeng dalhin sa Supreme
But
Court.
I think what we wanted to know is that there was a difference. What you're telling us is that that which deterred enforcers before has already been removed.
Removed.
That's your point,
That's
right?
correct. That's the first
Now,
point.
Attorney actually mentioned that
Let
earlier,
us-
Attorney Tranquil. He mentioned that earlier.
Yes, let's allow Congressman Coco. Yes,
Oh, yeah. So,
please,
so he
please continue.
Yeah, so he mentioned that 500,000 also. The 500,000 was taken out because it was replaced automatically by Article 32 of the Civil Code, where when a government agency has wronged somebody, it is to the discretion of the judge to already give actual damage, moral damage, and all other damages, and it becomes more equitable. And I'd like to quote on March 3, under the committee report in Congress, it says, under Section 27, the law provides damages for violation of the Act. We suspect that this is a reaction to the exorbitant 500,000 peso fine for violation of the Human Security Act. However, and I think it is in the right direction of the Honorable Congress would correct that because it really has a chilling effect on the law enforcers.
Okay.
The one who said
Thank
that
you.
was Attorney Cayosa,
Thank you,
IDP
Congressman
president.
Let me just allow you to respond to the second question, the 14 days. I think a lot of people would like
Thank
to
you.
hear that. From
That's
the
actually
original
the first
3 days
question.
detention to 14 days, before I ask the rest of our reactors.
Okay. As far as the 3 days to 14 days is concerned, we have to first understand that the 3 days is limited, has to be understood within the privilege of the writ of habeas corpus being not suspended. A lot of people go after the 14 days by saying, when the provision on martial law and the suspension of the privilege of the writ of habeas corpus only gives a maximum of 3 days, so mas maselan pa ito sa martial law. Those are exact words that were given in Congress. Ang sagot ko dyan is that since the Human Security Act, so 13 years ago, there already was the 3 days, and that has nothing to do on the situation where the suspension of the privilege of the writ of habeas corpus is in effect. So basically, matagal na, 13 years na the state can arrest for 3 days, can detain for 3 days, I mean. And with that detention for 3 days, by policy, we have changed it to 14 days. The reason being 14 days being the smallest number of days in the region, because terrorism, to fight terrorism, it's an international and regional affair. And in the region, Southeast Asia region and Pacific region, we have the smallest number of days of detention. And that operationally made us a haven for terrorists. In fact, we don't even have a legal definition of foreign terrorist fighters until the Anti-Terrorism Bill. So, for example, very quickly, sorry.
Attorney,
very quickly. Australia and Sri Lanka, 14 days detention without detention. Bangladesh, 15 days. Indonesia, 21. Pakistan, 30. Malaysia, 59. Thailand, 30 days. Singapore, 730 days.
Okay, thank you, Congressman Coco. I think Attorney Egon would like to comment on this. Attorney Egon, you might want to comment on the explanation of Congressman Coco as to the reason why it is presently 14, why the proponents pushed for a longer period of detention after a person is arrested. What is your observation on this?
When the previous Congress decided to limit the detention without judicial charge to 3 days, they were cognizant of the limitation set by the Constitution, which is maximum of 3 days, even for the extreme circumstances or incidents of invasion, rebellion, and the privilege of the writ of habeas corpus is suspended. So with much more reason now that it only covers terrorism, you cannot go beyond that. Now, we can cite all countries around us that have 100 days, 30, 75, 600. The big difference, my friends, is that these countries do not have the same constitution that we have. Their constitutions do not contain similar provisions with clear limitations. The experience of these countries also are not the same as ours. They don't have issues with accountability, abuse in governance. So that's the big difference. So we cannot just copy them simply because they put that in their
Attorney
laws.
Egon, I have another question for you. Having raised or given your comment on the statement of Kong Coco, my question is: there's a lot of comments or statement on this bill that it suppresses the right of people to express themselves. And of course, Congressman, I keep on saying Attorney Coco, Congressman Coco will be quick to say that there is a provision that says that the people we have the right to protest, right, to do mass action, and even participate in work stoppage. What do you see? What is your observation of this or comment on this provision?
Well, you can
Attorney
recopy. You can recopy all the provisions of the constitutions on the Bill of Rights in the law. It will not change the Constitution. As a matter of fact, these are surpluses. But what is questionable is paragraph 5, A, B, and C of Section 4, which says any act with the intent. So with that, it is so broad because it's any act. Under the Human Security Act, these were well-defined crimes under the circumstances. In these particular provisions that we cited, specifically in our submission, any act with the intent. But how can you determine intent? It gives so much leeway to the arresting officer and the detaining officer because it can be any act. It is the intent that they can
Attorney
induce
Egon, let me
that
now
justifies
proceed
that.
to Attorney General Manalastas. General Manalastas, you made mention a while ago of the provisions of Section 3, I think. You compared the provisions of the Human Security Law with the present anti-terror bill, right? You remember? Now, I would like to ask you, being there at the forefront of implementing the Human Security Law, let us try to refresh and help the viewers understand that under the Human Security Law, it was a bit detailed. It says homicide, murder, coup d'etat, sedition, rebellion, or any other acts would lead to fear, intimidation, widespread fear and intimidation. It was quite outlined. And the laws that are violated, offenses were outlined. Now, in the present terror bill, and I would like to hear your comment on this, on the present terror bill, it enumerates that the acts of terrorism would be if someone dies, okay, someone is killed, someone is injured, there is damage to property, right? Natatawa si Attorney Egon. There is damage to critical infrastructure, and there is transportation of weapons of biological destruction with the qualification. Ito yung gusto ko malaman sa inyo, and later on I will ask Attorney Coco, Congressman Coco to comment on this. There is a qualification at the bottom. It says any act of force or intimidation, right? Or that would pose danger to the public safety. And in addition to that, that which would change the political, economic, and social structure. So pag-iisipin ko, hindi ba ito yung rebellion? Hindi ba ito yung sedition? What's this? I think that's some of those who are reading the law are led to that conclusion. Ano ba yun? It's so, that's why they say it's so expansive in terms of scope. Anong tingin mo, General Manalastas?
Yung present Human Security Act, merong tinatawag na mga predicate crimes doon, which should be met first. So, yun yung condition precedent bago mo ma-prove na mayroong terrorism. So, naka-enumerate yun kung ano-ano yun. Some of them are violations of the revised penal code, others are special laws. So, it should be proven first na meet yung element. So it's really hard to be proving that on the part of the prosecution. Unlike before, when the definition of terrorism is very specific. So naka-enumerate lang doon what are these and what are supposed to be the consequence. Ano yung gusto niyang ma-attain? So in-specify yan ng present law, which is actually simpler. So actually, there was an effort to increase the number of predicate crimes. But this one, we find this to be simpler and mas madaling implement.
Okay. Now, Congressman Coco, what do you say? I'll allow you, Attorney Cayosa, to comment later. What do you say? There have been a lot of comments on the, some would say it's vague, some would say it's expansive. Those are their comments, no? And do you think that the law was intentionally made to be expansive so that it would reach out to a number of offenses? What do you think?
The idea is effectivity, and the definitions, hindi naman ito hinugot galing sa hangin. This actually is part of the UN Security Council resolutions. It's very similar to that, and in fact, the definition of terrorism by law was first introduced in 2012 under Republic Act 10168, Section 3. And you could see terrorism and terrorist acts are defined there. And with the Anti-Terrorism Bill of 2020, these are taken into consideration, what is existing law under the Anti-Terrorism Financing Act of 2012, as well as the UN Security Council resolutions, which are conventions that the Philippines is signatory to. So,
okay.
Again, it's existing and it could be questioned in the Supreme Court anytime.
Okay, Attorney Egon, do you want to say something about this?
Yeah, the good general is correct that under the Human Security Act, the predicate crimes are very clear, well defined. So there was no problem with that. If you look at the records of the Senate deliberations, but not much on the House kasi kinopya lang naman nila, the proponents of the Anti-Terrorism Bill seem to have changed the predicate crimes into inchoate offenses. So malinaw sa kanila, hindi mo pa ginagawa, intention mo pa lang, and that's why they put this term with the intent. Intention mo pa lang, sa tingin ng law enforcer, huhuliin ka na. That's where the problem is, because how can you define divine intention? It is, and now it's dependent on the thinking of the arresting officer.
So, Attorney Egon, I think what you're telling us is it gives so much discretion on the part of the arresting officers. So sabihin nila, it just because it gives too much discretion to the implementers of the law. Anong tingin mo dyan, Attorney RP, before I go back to Congressman Coco? Yeah.
You know, we see that discretion right now. I'll digress a bit, no? Like, for example, in our Cybercrime Prevention Act, if what is posted on Facebook allows our law enforcers to do warrantless arrests, which are actually happening right now, I don't think anyone can debate that fact. That is the kind of discretion which this definition brings in. You mentioned earlier, Attorney Tranquil, no, engages in acts intended to cause death or serious bodily injury to any person, and then nakalagay, or endangers a person's life. Endangers a person's life, that's very broad, okay? And then sabi, if it's to intimidate the public or create an atmosphere or spread a message of fear, or provoke or influence by intimidation the government. So for example, a mass action right now, okay, a mass action with this COVID-19 pandemic, does a mass action actually endanger the life of another person? And by numbers, you have a rally, a mass action. In a way, it's to intimidate the government to have this, that we have the numbers. That is actually under Section 4. So you are not only allowing the arrest of people actually doing that, but also suspected people. No, suspects, hindi pa ginagawa, pwede nang arrestuhin.
I would like to call your attention on that because there is a provision that says that even does it include banners or statements in rallies that would tend to, let's say, incite. Because if you look at the definition of inciting to sedition, okay, inciting not to sedition, to terrorism, let me go to you portions of the same. By speeches, proclamations, writings, emblems, banners, or other representation. Does it mean, therefore, if you have, this is a question, does it mean, therefore, if I do a rally now, you cannot do banners and your banner should be friendly banners. And as you know, yung mga banners na yan, galit talaga yan. Okay, galit yung mga banner na yan. Does it affect the right to free expression? What do you think, Attorney RP?
Definitely, no, definitely. That's why I'm saying that whose discretion will now be exercised? You are now putting that discretion on law enforcers to be able to arrest without any judicial warrant. And then probably some of our co-panelists would say that, uy, under the law, nakalagay, it's not intended to, provided it will not include advocacy, protest, dissent, stoppage of work, industrial or mass action, and other similar exercises of civil and political rights. Alam natin as lawyers, this is a legal defense. This is a defense that you will raise before the courts. It's not a defense that you will raise while you are being arrested. And I am speaking as a human rights lawyer from experience of people who we have been assisting being arrested. Lawyers can't do anything. In fact, if you recall, even lawyers who were doing their job last year or 2 years ago in Makati, that bar raid in Makati, were even arrested. Were they even charged? Charges were dismissed months later, but they were arrested. Okay, so that's the point here. That discretion and that danger of people getting arrested because of this particular law. Okay? Cases will be dismissed for sure, but arrest will happen.
Thank you, Attorney RP. That's very clear. Let's proceed to General Manalastas. General, I have this question. You're presently part of the Anti-Terrorism Council. Could you share with us the successes of this council? And do you think there is a need to further bolster what you already have, meaning the power that you already have right now? General Manalastas.
Well, of course. That's the very reason why we are supporting this anti-terrorism bill, because we know that the existing Human Security Act is very weak. It could not attain its purpose of actually fighting terrorism. That is why for a long time, and we work on this, we crafted an anti-terrorism bill and forwarded that to the House and the Senate. Matagal na ito eh. Kaya yung may mga ibang claim na ito, ba't inapura ito? Hindi inapura yan eh. Because we already forwarded copies to the Senate and House of Representatives before. Si Senator Acop, si Congressman Acop yung nag-sponsor doon sa ibaba, si Senator Soto doon sa itaas. So, noon pa kumikilos yan. And of course, hindi natuloy, hindi na-aproban. And so, yun yung nagiging problema natin because for a long time, hayahay yung mga terorista sa South. Ang dami nang nangyari and we should not enumerate anymore the different incident that has been transpiring. Even now, I'm sure that at this very moment, kumikilos yung mga terorista. And if we will not have a strong anti-terrorism law, then wala, magpipiesta sila dito. Naipaliwanag na yan. Yeah.
General Manalastas, very quick question, and I need a quick answer. As it stands today in the Anti-Terrorism Council, do you designate? Can the council designate?
Yung president ang may power na mag-designate. Kaya dinesignate niya yung...
so, the president of the Anti-Terrorism Council doesn't have that power?
We recommend. Of course, I just want to correct. I'm not a member of the Anti-Terrorism Council. It's composed of 7 cabinet secretaries. We work for the council.
Okay, thank you, General. Attorney Egon and Congressman, you want to say something? Okay.
Designation was first
You want to say
introduced by Republic Act 10168 or the Anti-Terrorism Finance Act. It wasn't clear in that law on who would designate. The only group that was designated so far is the NPA, designated by the President in 2017. The anti-terror bill qualifies the power of designation or the duty of designation to the Anti-Terrorism Council utilizing 2 methods. One is an automatic designation by adopting those who are designated by the UN Security Council or those who have been prescribed by the UN Security Council. And second is designation based on the anti-terrorism.
Congressman Coco, so Presently, under human security law, we don't have designation, right? It's on a separate law.
Separate law. Yes, that's correct. In the
9.3.
Human Security Act
Right.
of 2007,
Let me ask
what we
Attorney
have
Egon.
is proscription.
Okay. Attorney Egon, what do you see, or what is your view on this designation, which is new under the Anti-Terrorism Bill? Although, according to Congressman Coco, that was already part of a previous bill. Yes. What is your view on this?
Yes, but the fact that that it was not questioned then does not mean that we cannot raise the continuing constitutional issue, because the designation under Section 25 is ex parte, probable cause. There are no clear guidelines, and it doesn't stop there. Once you are designated as a suspected terrorist, then the Anti-Money Laundering Council by itself, or upon request of the ATC, can actually freeze your assets. And to our mind, that is already taking of property without due process of law. Compare that process with the prescription with the Court of Appeals that allows we have to have an executive agency to do the job of a judicial body.
Okay. Congressman Coco, what can you say about that? It says that it's a deprivation of property. Because let me outline this for you, for everyone, and not for Congressman, for everyone. According to statements of those who are opposed or the critics, they said that the very moment that there is a designation by the ATC, your accounts could be frozen. Okay, your account could be frozen, and they could look into your bank accounts. Tama ba yun, Congressman Coco? Tama ba yun?
That's an incorrect understanding. The designation merely notifies the Anti-Money Laundering Council to look into these. It doesn't automatically freeze into the account. So basically, para kang naka-watch list under the Anti-Money Laundering Council. And the Anti-Money Laundering Council, by their own rules and by the laws that govern our anti-money laundering laws and anti-terrorist financing laws, sila na ang magde-determine whether there is reason to freeze such assets. So basically, out ang ATC pagdating sa pag-freeze ng mga assets. It's entirely the Anti-Money Laundering Council. That's why you need to read those separate laws as far as that. Ang designation, the effect of designation is basically just saying, hey, Anti-Money Laundering Council, tingnan nyo nga ito, we suspect them as terrorists. And bahala na ang council under their own rules and not the rules of the Anti-Terrorist Council.
Okay, Attorney Egon, you would want to say something?
Yeah, but the simple words of the law doesn't require much understanding. That's the
Medyo natigil ata tayo.
There are no legislators explaining it to them while they operate. So giving so much leeway to the law enforcer will create trouble and probably violations of rights at the enforcement level.
Okay, I think before I move on to another point after that statement of Attorney Cayosa, I think I have read in the provision of the law that it is a step. It is a step-by-step wherein there's a designation, and then after a designation, it is the AMLC that could initiate on its own, or the ATC could request the AMLC to do it. Okay? So again, I think those are matters that we could further discuss. Let me ask you this next question. Okay? How about wiretapping or intercepting information? Okay? Matanong ko muna si General Manalastas. Ito bang nagagawa nyo na ba ito? Have you actually requested the courts for authority to do information? And I think based on the present provisions of the terror bill, alam nyo, yung mabigat doon ay nakalagay doon kahit yung past information and the period of time that it would cover is a lot of time. What do you say, General? Nagawa nyo na ba yan before?
Okay. I've been with the Anti-Terrorism Council Program Management Center since 2016. And since then,
Yes.
wala pang request, wala pang nagawa na ganoon. But it's in the law, in the law. So yung
Okay,
worry,
right.
yeah.
So it's in the law. But based on your experience in the last 4 years, that has not yet been actually applied. Okay. Now, RP, let me ask you this. There was a Attorney RP. There is some sort of comment on the whole departure order. Okay, whole departure order. And I think reading the provision of the law, if the evidence appears to be strong against the terrorist, and I think na-mention niya ng IBP, that the passport could be cancelled. Do you think that's within the power of the ATC or under the law to cancel the passport of someone who is believed to be a terrorist? There is strong evidence. What do you say?
Oh, well, two things here, no, two things. Number one is that when we talk about whole departure orders, when we talk about wiretapping, these are the rights to privacy that are involved here are not limitless. Okay, as long as there is judicial intervention, the Supreme Court has been very consistent that that could be an exception. Okay, these are judicial safeguards, and that's my point about removing the discretion. Okay. Now, with regard to passport, unless it is proven actually that you are guilty of a crime, you cannot be deprived of your civil and political rights. Part of our civil and political rights is the right to travel. Okay, it could be limited by a whole departure order, again by a judicial intervention. But if it is purely executive, by removing, canceling your passport, without finality of any judgment, then that is actually questionable.
Okay. Attorney Egon, you would want to say something on that? I know IBP has a position on that. We can't hear you.
More accurately, it is under provision of the law, I think,
Okay. Congressman Coco, ikaw muna. Yes.
Okay, so
Congressman
I
Coco.
agree with
Naputol si Attorney Egon and then we'll go through.
RP. Yeah, I
Yes.
agree with Attorney RP that it has to be the courts that would restrict the right of travel. That's why on Section 34 of the Anti-Terror Bill, it is the courts that determines whether to restrict the right of travel or the cancellation of the passport. Noteworthy also is that Section 34 of the Anti-Terrorism Bill of 2020 is very similar to the wordings of Section 7 of the Human Security Act of 2007. So, yeah.
So, Attorney Egon, you want to say something?
Yeah.
You were interrupted by the...
yes, as I was clarifying,
Yes.
it is really that provision that says that even if you release on bail because the evidence is strong and the court grants you bail, upon the mere application of the prosecutor, and the law is very clear, it says the court shall. So the court will issue travel restrictions. Worse, it will issue house arrest and you're held incommunicado. So what's the sense of granting bail when at the same time you take it away by putting him on house arrest and getting him incommunicado? So it renders nugatory the provision of the Constitution and presumption of innocence and the right to bail by citizens.
Okay. Alam nyo, we didn't notice that time is really running that fast. I would give everyone a few seconds because it's already, I think, more than an hour and a half. We're so excited about this. I'll start with Congressman Coco. Congressman Coco, just a quick word that you would want to give our listeners and our viewers on this. And then I will ask the rest of our reactors to say their final piece. So just for a few seconds, maybe 30 seconds. Yes. Thank you, Congressman Coco. Please proceed.
So I'd like to say thank you to everyone for allowing this healthy discussion. I just want to request that we have to be, since it's a very important issue, we have to be very honest. And we also have to be very open to each other and present ourselves in an honest and proper fashion. We cannot make and we cannot put misinformation, disinformation, and politicize this law, because this law, and we all agree that it's against terrorism. And we just have to help each other fight the crime of terrorism. Thank you.
Okay, thank you. Congressman Coco, let's proceed to Attorney Egon for a final word.
Evaluate it based on that. And if we have to strengthen our anti-terrorism law, by all means, but let's do it within the carefully crafted balance, safeguards, and guarantees of the Constitution. It cannot be a reason to just disregard clear provisions of our Constitution.
Okay. Final word for General Attorney Manalastas.
First of all, I would like to thank you, the organizer, for inviting me. And again, it is our position in the Anti-Terrorism Council Program Management Center that we really need a robust law, something that is effective, something that will achieve its purpose of deterring the act of the terrorists. We will not be able to do that. That will not materialize in the present Human Security Act that we have. There will always be questions as to its constitutionality. The sad thing is some of those provisions being questioned has already been existing for a long time, and that was not questioned before. So let's give it a chance, and then let's history say whether we made a mistake or not. The fact is, kailangan natin ito. Kailangan nating labanan ng terorista.
Thank you, Attorney General Florentino Manalastas. Then, as a final word for coming from Attorney RP. We can't hear you. We can't hear you.
Sorry. Thank you very much to Ateneo Law Alumni Association, to the organizers, and to my co-panelists, especially to the main discussant, Kong Coco. I just want to end by saying again that when we talk about human rights, there's really nothing political that should be put into it. There should be no color. So we're discussing things right now based on the context and based on the inequity that was actually pointed out earlier by Kong Coco. And if we have a law such as this, and if we have admittedly still weak institutions, okay, and a slow justice process, then a lot of those who are at the lower part of our society would feel the brunt of falling into being arrested. Okay, so this is what we are safeguarding: the human rights, which is really non-political. Thank you very much.
Thank you very much to the presenter, Congressman Jericho Coco Nograles, salamat sa iyo. And to our reactors, IBP National President Domingo Egon Cayosa, General Manalastas, Florentino Manalastas from the Anti-Terrorism Council, and from the Ateneo Human Rights Center, Attorney RP Santiago, and of course, as a final word from the Ateneo Law Alumni Association, we would like to thank you for joining us this afternoon. And I will have to restate our commitment as an organization. We will always find a platform to have an open discussion of issues objectively. And we will see to it that we will participate in educating the public. And should our help be needed by agencies of the government to educate our implementers, the Ateneo Law Alumni Association will be ready to assist. Thank you very much and good day.
The Ateneo Law Alumni Association has evolved from its image of a boys' club in the early years to the image of an active alumni association of men and women for others.
I think it's very important to remember that the Ally performs a very important education value. The education of our graduates ends not with graduation, but with their continuing practice in introduction into the legal world.
This is a big task, but I believe everything is possible as long as you believe in our dear Lord. And as Atenean lawyers, we do believe, and with your help, we will be able to do it. Let us continue to be men and women for others. Join the Ally.
Join us! Join us!
Join us.